Hello and welcome to ILBSG. Today we will talk about the recent update from USCIS regarding CSPA. USCIS issued updated guidance regarding when an immigrant visa number becomes available for purposes of calculating the non-citizen's age under the Child Status Protection Act, or CSPA. Previously, USCIS considered a child's age frozen if a visa number was available under the final action date chart of the Visa Bulletin at the time the I-485 application was filed. Now, the policy manual has been updated to reflect that USCIS will instead use the dates for filing chart for calculating a child's age under CSPA. In other words, the child's age will be frozen when the I-485 application is filed based on the date of filing chart, even if a visa number is not yet available under the final action chart. This provides desperately needed relief for those at risk of aging out due to lengthy processing times and persistent visa backlogs. Under CSPA, a child's age is calculated by looking at the actual age when the priority date for the green card became current or the date when the underlying immigrant petition was approved if a visa was immediately available at the time of approval. The number of days the immigrant petition was pending is then subtracted from that age to determine the child's CSPA age. If an individual's CSPA age is under 21, the individual meets the definition of a child for immigration purposes and, therefore, remains eligible for the derivative green card. In simple terms, the calculation is age at time of visa availability minus pending time equals CSPA age. Previously, USCIS determined visa availability for purposes of this calculation using the final action chart of the Visa Bulletin. Now, it will instead consider the dates of filing chart for CSPA age calculations. This is great news since the filing chart typically includes much earlier dates. For example, let's say an applicant is 21 years and 4 months old at the time the priority date for his parents' I-140 petition becomes current under the dates of filing chart. That month, USCIS announces it will accept I-485 applications based on the dates of filing chart. So the applicant wants to know if he is eligible to file his green card application even though he's already turned 21. If his parents' I-140 petition was pending for 6 months, the CSPA calculation would be as follows. 21 years and 4 months minus 6 months equals 20 years and 10 months. In this scenario, the applicant's CSPA age is under 21. As such, he remains eligible for derivative green card status and can file the I-485 application as a child for immigration purposes. When he files his I-485 application, it will effectively freeze his age under CSPA. If an individual previously received an I-485 application denial based on having aged out, USCIS has announced it will accept a motion to reopen. While MTR must typically be filed within 30 days of the decision, it can accept an untimely filing if the delay was reasonable and beyond the non-citizen's control. Here, the policy change justifies the delay, so USCIS will accept MTR filed on this basis. If you have questions about this Child Status Protection Act policy change or believe your application or eligibility may be affected as a result, please reach out to an ILBSG attorney today. We are here to guide you.